Hello everyone, this is Robert Mansour. I'm a lawyer in the Los Angeles area, and I want to welcome you to this online webinar entitled Estate Planning 101. During the next 45 minutes or so, we're going to be discussing the fundamentals of estate planning so that you can learn more about it, especially if you don't have too much knowledge about the area. This will be a nice introduction so that when you do meet with your lawyer to create your estate plan, you'll have a much better idea of what's involved. So we're going to talk about things like wills and living trusts and different forms of ownership such as joint ownership and beneficiary designations and a whole bunch of other things that I think will help you understand this area a lot more. If you wish to get in touch with me to create an appointment to get something going, you can call the phone number at the bottom of the screen, which is 661-414-7100, and the website is mansourlaw.com. You can see it there at the bottom right of your screen. One of the reasons I created this webinar is because I've done many different presentations over the years I've been a lawyer, and one of the problems with seminars is that sometimes people can't make it. They can't get to the location, or it's at an inconvenient time. So I figured, you know what, I'm just going to put this presentation on my website, and that way folks can watch it at their own leisure and at their own time. So let's get started and let's see if we can learn something. First, we'll start with some common objections to estate planning. The truth of the matter is, estate planning can be very boring. I mean, let's face it, talking about estate taxes and different kinds of living trusts would cause most people's eyes to glaze over. And sometimes that does happen, so we're going to try to make it as interesting as possible. You know, we can't compete with your favorite movie or a great book, but we'll do our best to make this as interesting as possible. One of the other objections I get is, people say, Rob, I'm too busy. I can't take the time to do all this. And frankly, it is kind of involved. You do have to carve out some time and do it. And many people are busy, they're driving their kids back and forth, doing their work, doing this, doing that. And sometimes it's very difficult to find the time to do these important things. But I promise you, you will not regret having taken the time to protect yourself and your family. So don't let those things get in your way. We are so busy creating our estate that we don't take the time to protect our estate. Estate planning is for old people, Rob. I'm not old people yet. And this is one of those things, we've been conditioned to think that estate planning is for old people because we see it in the movies. People are on their deathbed signing legal documents, and then they'll have some kind of meeting where they'll say, ladies and gentlemen, the reading of the will after the old person has passed away at the hospital. Frankly, estate planning is not for old people, it's for wise people. People who create a plan. I mean, you can be in your 20s, 30s, 40s, it doesn't really matter. You got to sit down and come up with a plan for your estate. How are you going to protect yourself? How are you going to protect your family? And these are questions that are not exclusive for old people. I think one of the reasons this happens is because people wait until they're old before they do this, and they keep procrastinating. So maybe that's where it comes from. Some people think that if they create their estate plan or do their will or their living trust, they're going to die sooner. I have news for you. You're going to die anyway, so you might as well make sure you are ready for it and you have a good plan in place so that you're protected. Estate planning is for rich people. This is probably the biggest problem I have to explain to folks. Estate planning is not just for rich people. I mean, yes, rich people do it, but ladies and gentlemen, we have to learn from rich people. They're not rich by mistake. They are rich for a reason. And they are rich because they use the very same tools that are available for average people. And average people just don't take the time to do this. And so what happens in this country, we generally lose wealth within 1 or 2 generations. That's right, between 1 and 2 generations, the wealth is lost in this country. And that's generally because people don't create a plan. And I think part of the reason is that they think that estate planning is for rich people. We'll come back to that in just a second. And there is a condition called paralysis by analysis. Sometimes people can't agree on who their trustees are going to be, who their executors are going to be, who they're going to name as guardians for their children. And as a result, basically they analyze it far too much, and there you have it. Too much analysis leads to paralysis, which leads to absolutely nothing. Nothing happens, nothing is planned, and the client is back at square one. I think one of the biggest problems, getting back to something I just said a few minutes ago, is this word estate. When you say estate planning, I think people think of the word estate, and frankly, I think it's a dumb word. It conjures up the wrong image. So for example, people imagine like a mansion on a hill, or they think they have to be playing polo with their friends on the weekends. When they think of the term estate, they think it's only for rich people. They imagine counting their money, in the evenings by the fireplace or something like that, or driving really fancy cars. Again, estate planning is for wealthy people, but it's also for people of all socioeconomic backgrounds. It's not just for rich people. And the problem is the term estate conjures up a lot of these images. So therefore, I would just like to say that estate planning is, people say, well, if it's not for rich people, what is it for? And I tell people that the word estate simply refers to all of your stuff. If you've got any stuff, you might want to consider doing an estate plan. So people say, okay, well, what kind of stuff are you talking about, Rob? And I say, well, we're talking about things like real estate. If you have an apartment or a condominium or a house, land of any sort, bank accounts, savings accounts, checking accounts, those types of things. Stocks. A lot of people own individual stocks, or they own like investments. They have an investment account at a brokerage firm, so investments count. IRAs is part of your estate. That's an individual retirement account. An individual retirement account, 401ks, 403bs, pension plan. All of these things are part of your estate. They're part of your stuff. Jewelry can be part of your stuff, or any kind of valuables that you might have, such as a baseball card collection, or maybe you like to. I had one client; she collected dolls from different countries. I mean, it was a very expensive collection. That becomes part of your estate, part of your stuff. Another thing that people sometimes forget about is insurance accounts, insurance products such as life insurance. Whether it's a whole life policy, a term life policy, those insurance accounts are part of your stuff. They come into your estate after you die, but they're nevertheless part of your stuff. Some folks have businesses, and a business can be part of your stuff, part of your estate. And you have to ask yourself, what about that business? What's going to happen to it? Who's in charge if you're not in charge? These are the questions that we need to ask. So forget about the word estate planning. We're just going to call it stuff planning, okay? If you've got stuff, let's make a plan for it. So stuff planning is probably a little bit easier to get your mind around if you don't like the word estate. Frankly, I'm not crazy about the word estate, but I wasn't there when they came up with the term. All right, so let's move along. A lot of clients ask me, look, Rob, do I really even have to bother with this? Why should I even bother? And I tell folks, look, you don't have to do anything. You don't have to go to the dentist. You don't have to go to the doctor. You don't have to brush your teeth. You can do whatever you want. You don't have to do estate planning. However, if you want to control who receives your assets after you pass away, and if you want to reduce legal fees and reduce potential taxes, you might want to consider estate planning. Also, if you're incapacitated, something happens to you, you're in a coma, you have an aneurysm, you get Alzheimer's disease, dementia, anything, a car accident, you can control your assets even if that happens. You will have also control over medical decisions. You're basically trying to figure out, if something happens to me, whether it's incapacity or death, how can I make sure that everything is protected? Some people say, Rob, I don't have enough money to do estate planning. What are you talking about? And again, this kind of harkens back to the initial issue that I talked about. But I always tell people the following. The less you have, the more you have to lose. That's important. Think about it. The less you have, the more you have to lose. So if you're a millionaire and you lose one of your millions, you're probably going to be okay. But if you're like most people, with several $1,000s in the bank, or maybe hundreds of thousands of dollars in the bank, and maybe some real estate, basically the question is, okay, if you lose a large portion of that, isn't that going to be a pinch to your family? So, yeah, very wealthy people, they can afford to lose something, but most people can't afford to lose that. Why lose it if you can protect it? There are also reasons to do estate planning that have nothing to do with money, and it's more to do with intangible things or issues that are a little bit different from just who gets what. One of the examples that I use to illustrate this is called the irresponsible ex-wife or the irresponsible ex-husband. I had a client one time who came to me and he'd just gotten a divorce, and one of the reasons he got a divorce was because his wife couldn't handle money. So he comes to me and he goes, Rob, he says, do I really have to do this? I told him, look, Tim, if you do nothing at all and you remain unmarried and you die, everything will go to your daughter. And he goes, perfect, that's exactly what I want. I said, hold on a second. Don't you have a young daughter? How old is she? And he says, well, she's 8 years old. I said, Tim, you realize that your 8-year-old can't inherit real estate from you? The insurance company is not going to write a check to an 8-year-old daughter. I said, what you need to do is you need to protect yourself. I said, the insurance company won't write a check to your daughter, but they'll write a check to your daughter's guardian. I said, who's your daughter's guardian? And he says, oh my goodness, it's my ex-wife. I said, so the insurance company is going to write a check to your ex-wife. Is that what you have planned? And he says, oh gosh, I don't really want it to work out that way. So he created an estate plan that protected his estate from his ex-wife and made sure that everything ultimately went to his daughter. So you'll see that has very little to do with, reducing legal fees and taxes. There are other reasons to create an estate plan. So let's move along here. There's another point on this particular slide. You want to give your team the legal tools that they need. You want to give your team the legal tools that they need. People can't just act on your behalf and help you out just because they're related to you. They actually have to have the legal documents that empower them to do so. So one of the analogies that I often use with clients is I say, look, think of it like a big toolbox, okay? So if you have a toolbox in your garage and it's got, a hammer and some nails and it's got a screwdriver, a wrench, depending on the problem that you have, you reach into the toolbox and you grab whatever you need to fix the problem. Well, it's the same thing with an estate plan. An estate plan is a legal toolbox. And it looks a little fancier. It's in this nice binder and everything, but inside is the same tools, except this time you're going to have things like a will, a living trust, powers of attorney, healthcare directives, marital property agreements, assignments of interest. A variety of different tools that will be in this toolbox that people that you trust can reach in there and grab whatever they need to address the situation. Who needs to do estate planning? Oftentimes this is a question that people ask me, and I say, look, older citizens might want to think about estate planning. After all, they are older and we don't want to wait too long before it's too late. Families of all sorts, children from previous relationships. If you have children from previous relationships, that can be a little bit more complicated, so you want to make sure that we protect everybody involved. Single people also ask me, they say, Rob, why do I have to do an estate plan? I'm single. And I tell them, look, it's because you're single. If you're single, you don't have that automatic protection with a husband or a wife. Even husbands and wives have difficulties sometimes helping their loved ones because they don't have the right legal documents. But if you're single, it becomes even more difficult. So you want to make sure that you have that toolbox for your family so they can have the tools that they need. So if you're single, if you have friends or family who can help you, they need a toolbox too. One of the tools that people often use is a will. And a will is a good tool to have in your toolbox, but let's talk a little bit about it. A will is simply a wish list of where you want your stuff to go when you die. So, you say, I want my car to go to so-and-so. I want my jewelry to go to so-and-so. I want my painting to go to this person, etc. That's all it really is. A lot of people don't know that a will is of no use while you're still alive. In other words, a will only goes into effect after you pass away. It's not a useful document, really, when you're still alive. So it's just a wish list of where you want your stuff to go. Also, very important to know that a will only controls assets that are in your name alone. So if you own property jointly, or you're using beneficiary designations, or you have a business owning some property or some assets, what your will says is irrelevant. You can write 1,000 wills. It doesn't make a difference. The only thing a will controls is assets that are in your name alone. Very key point. If you have a will will be enforced by the probate court. After all, your assets are not going to pass magically to the people that you love. You have to go to court. Generally, your executor would be involved in doing that, and the court would supervise the transfer of those assets. That's what probate court is all about. The court-supervised transfer of assets. The probate fees are very expensive. If you're going to have only a will and it's going to go through the probate process, probate fees can be about 5% of the gross estate. Not the net, but the gross estate. And also there can be executor fees, attorney's fees, court filing fees, appraisal fees, etc. So it can be very expensive to go through the probate process. There is a mistaken belief that a will covers everything. Remember, a will covers only assets in your name. So if you have, let's say you have a life insurance policy that says, Johnny gets my life insurance, and then you own a bank account and you've got your brother on title with you, or a cousin, or whatever the case may be. What your will says is meaningless. The will doesn't cover everything. So if you hold an asset jointly with somebody else, they get that asset. If you name a beneficiary, that person gets that asset. So your will is meaningless. Probate is a pain, ladies and gentlemen. I hate to tell you this, but it's my least favorite part of my practice. I try to avoid it like the plague because it is super complicated, and it takes sometimes between a year to 2 years to accomplish. And my clients just really resent the entire process. It's very laborious, it's expensive, 5 to 8% national average or more in fees. And also, the mortgage on the house keeps coming. The bills keep coming, ladies and gentlemen. Everybody doesn't hold on while the probate is going on. I had a client one time, he had to walk away from a $900,000 home that his parents had because he couldn't afford to keep paying the mortgage. And as a result, the mortgage company foreclosed upon the house. They didn't care that so-and-so died. They want that monthly payment. And so the question is, does your family have the money to keep paying all your bills? Are there enough liquid assets to pay for those bills that just keep coming and coming during the course of the probate? Frankly, who has the time to do this, folks? I mean, you probably barely had time to watch this webinar. Do you really have time to spend 2 years in court doing a probate? A little bit more on probate. A lot of people don't realize that probate is a public affair. In other words, anybody who wants any information about your assets can just go get your file. They can go to the court and pull up your file and take a look at everything that they want to look at. All of your creditors, your family, they can just look at that file and see whatever they want to see. A probate is relatively easy to contest. In other words, if you have an objection, you can just show up to court. I mean, you just get there and tell the judge what your grievance is. I tell people that it's equal to an invitation for disgruntled family members and creditors. I mean, a probate is like a public party. You're throwing a party for everybody, and anybody who wants to come can just come. And that's not very private. It's not what you might have in mind for your family. Some people tell me, well, Rob, our family gets along very well. We're not going to have any of these problems. And I say, look, most of the time, many times, families do get along very well. But I must tell you, when you mix in money, you mix in ill feelings, you mix in sibling rivalry, you mix in real estate, you mix in sons-in-laws and daughters-in-laws and other in-laws, it starts to mess things up. So you might think your family gets along really well, but I have news for you. The probate courts are full of families who used to get along really well. So you gotta be careful not to hang your hat on that assurance. It's so much better to plan ahead than to rely on our family gets along very well. One of the issues that comes up when we talk about estate planning is minors. Minor children in California currently, anybody under the age of 18 is considered a minor. So what's going to have to happen is the court has to get involved and appoint a guardian for that child. And hopefully it's somebody that you've chosen, not anybody who wants the job. The court will control the finances for the child, and the guardian has to account to the court regularly about what they're doing with the money, what they've spent it on, what they intend to do. Sometimes they have to get permission from the court. It's a real big hassle and very expensive. It goes on for a long time. Also, if you want, your child will inherit everything at age 18. That may not be what you want. Do you really want your children inheriting everything at age 18? Are they prepared to manage everything at that age? People do come out of the woodwork and influence them, and sometimes that may not be the best plan for your kids. There's also an approach called doing nothing. People say, yeah, I'll get to it someday. And the do nothing approach is, it's very common. It's the very easy plan. It's certainly very popular. And it's free. You might be doing this plan right now. You might be the person who is doing nothing. However, at your death, the probate court will get involved with your assets, and your assets will be distributed according to California state law. So therefore, again, that may not be exactly what you have in mind. At your incapacity, the court might also get involved. This is something called a conservatorship. A conservatorship is like a guardian for a grown-up. In fact, in some states, they still call it guardianship. So a conservatorship is where you can no longer handle your own affairs, and somebody has to go to court and petition the court for permission to handle your affairs. And they also have to report to the court regularly. It's a very expensive affair. It's very embarrassing in some ways. You have to be declared incompetent by the court. Wouldn't it be nice if you had a legal toolbox that avoided all this mess? A very popular approach is joint ownership. A lot of people own property jointly. If you take a look at this happy family here, let's call this Anne and Tom. So let's say Anne and Tom are here, and they own everything jointly. That's a lot of married couples do that. So let's examine this a little bit more carefully. When you own things jointly with other people, the rule is last man or woman standing gets the entire property. Last person standing gets the entire property. So let's say 2 or 3 people are holding on to a piece of property jointly. The last person alive gets full control over that asset. So therefore, if you own something jointly with others, you have to understand, if you pass away, you have lost control of that asset. You don't have any say as to where it goes. Some people use joint ownership as a way to postpone probate or avoid it. So they say, I know, I'm just going to put Johnny on property with me, and then when I die, Johnny will get the property. And I tell people, yeah, that is a way to avoid probate, but at some point there's going to be that one person last man standing, and that person is going to get everything. And if there's the last name on title, it has to go through the probate process. Also, you might be adding an unintentional bullseye to your asset. So some people, for example, they'll put their kids on title to the real estate with them, and the mom will say, I know, I'm going to put Johnny on the real estate with me. And then when I die, Johnny will get my property. And I'm like, well, that's true, but you've also added a bullseye to your asset. What does that mean? That means any trouble your co-owner gets into, so in this particular example, Johnny, any trouble that Johnny gets into, that asset is now subject to creditors, bankruptcies, divorce, lawsuits, and those people are going to come after that property. They don't care if you also own it. All they do is come after everything with Johnny's name on it. And if that happens to be a bank account that you have or real estate that you have, they don't care. So you could end up losing a good portion of your asset to something simply because you decided to add somebody to your property. Also, when you add an owner to a real estate parcel or to an account, you can't just take them off. You can't go to the bank a week later and say, you know what, I put Johnny on title with me, but frankly I don't like him anymore and I want him off. Too bad. Too late. He is now a co-owner with you, and he has to go affirmatively take his name off the account. take his name off of the title. So you can't do that yourself. So be very careful before you add an owner to an asset. If your co-owner becomes incapacitated, remember the court might get involved because they're incapacitated. And that means that suddenly you basically, for all intents and purposes, are owning something with the court. Not a very good co-owner in my opinion. There is also a cost basis issue that a lot of people forget about. When you add somebody to title, you are giving them the cost basis for the asset, which means what you paid for it when you first acquired the asset. Now, if you acquired the asset long ago and it was for relatively less than what it's currently worth, you might be burdening that person with more taxes than they otherwise would have to pay. Now, it's complicated and I can't explain it all in this particular webinar, but just keep in mind that sometimes it is better for people to inherit property than it is for you to put them on title with you, especially from a tax perspective. They might end up paying more taxes than they otherwise would need to. Also, leaving everything to one spouse can lead to something called estate taxes. Now, few people suffer from estate tax problems because, you have to be fairly wealthy to have that problem. But if you leave everything in one basket when you pass away and just give everything to your spouse, which is what most people do, you might be unnecessarily subjecting your estate to additional taxes that you can avoid depending on the kind of living trust that you have. So again, too complicated to get into on this webinar, but realize that joint ownership and just giving everything to one spouse is not always the best approach. There are also other reasons to create different strategies that don't have a lot to do with estate taxes. And ladies, let's not forget about your husband's new wife. Now, I speak facetiously here, but the truth is that when you die, your husband is going to find a new wife. And if you think I'm kidding, let me introduce you to Elaine. She is your husband's new wife. There she is. Isn't she beautiful? And she's going to make a move on your husband, and they're going to get married, or she will influence him to do some things that you probably don't have in mind with your estate. So all of a sudden, her family is inheriting everything, and your kids are getting nothing. So Elaine is going to screw things up for everybody. And frankly, gentlemen, don't get too comfortable because your wife's new husband, Marty, is also going to do the same. Now, I'm being a little bit silly here, but the truth of the matter is people are living longer and they are meeting other people and they are falling in love and they are getting married, and that person doesn't necessarily have to marry them. They can just be their new, quote, companion or friend. And that person comes into the picture and messes things up for everybody. Suddenly the assets end up going to different people and not where you intended things to go. So let's take a look at our example here. At the very top of the screen you'll see Ann and Tom were married, but Tom has an X through his face because Tom dies in this example. And then Ann marries Marty. Remember Marty? He's right over here. So when Ann marries Marty, so here we have them getting married after Tom died. And then Ann dies, and remember, they own everything jointly. When Ann dies, guess who gets everything? Marty. Marty gets everything. So what have we done? We've had an unintentional disinheritance. These lovely children in the photo are going to get zero. Why? Because of joint ownership, one of the most convenient yet dangerous ways to own property in this country. Remember, I told you wealth is lost in this country within 1 or 2 generations? Well, joint ownership is one of those main culprits of this. Let's take a look at other strategies that people employ. Sometimes as people get on in their years, they just start to give their stuff away. They say, you know what, I'm just going to start gifting my assets away. One of the problems that actually just popped up on the screen here is when you gift something to somebody, you're also giving them your cost basis for the property or for the asset. Remember, sometimes gifting seems like a good idea, but what you're doing is burdening the person with an unnecessary tax when they come to sell that asset. You may want to rethink that. Also, you lose control if you give an asset away. So if you give somebody something, you basically can't keep controlling that asset. If you give Johnny $5,000 and Johnny spends the $5,000 in Vegas, you've lost control of what you've given away. So good luck getting the gift back. You can't just take it back once you've given it away. So let's say you gift a house to somebody. You say, here's the house, and then all of a sudden you need that house for some reason. And they've already sold the house. It's too late. You can't get it back. Of course, the question is, what if you need it? Sometimes people gift things away, and then they realize as they get older that they have health care needs that they don't have enough money to care for, to pay for, so they have to use their assets to leverage and be able to pay for their health care. But if they've given everything away, good luck. If you need it, it's very difficult to get it back. Usually you can't. Some people name beneficiaries on their assets, like 401ks, life insurance policies, bank accounts. Sometimes people will just name a beneficiary on those assets. And there are times when that's very appropriate and not a bad idea. But keep in mind that if you name beneficiaries like minors, the court's going to get involved. The beneficiary has to be able and legally able and competent to accept the item. So there's nothing wrong with it, but the court will get involved if your beneficiary becomes incapacitated. The court might get involved if your beneficiary dies at the same time as you do, or if they die before you and you forget to update your beneficiary designations. Some people I've seen just write the term my estate as the beneficiary. You know, they'll say, who is the beneficiary? And they'll just write my estate. Not a good idea, because the court has to get involved in that, because it's not very clear what is meant by my estate. Basically means you have to go get a formal estate going with the court system. Also, if you have any minors, in many cases the asset cannot simply go directly to that minor because of the fact that they are a minor. Another tool in the toolbox that is very helpful is the living trust. People often talk about living trust, but they don't quite know exactly what it is. So here it is. Here's the definition. A living trust is a contract where you outline what happens with your stuff. Remember, we talked about your stuff. You decide who gets what and under what conditions. Anything in your trust is governed by your rules. Your trust governs anything in the name of that trust, and people sometimes not quite sure what that means. You say, Rob, what do you mean something is in my trust? And so I've created this slide. It's called How Do I Put Things in My Trust? And what I mean by that is that you're changing title to your assets. So you're taking your assets and they're no longer just in your name like they used to be. You're going to put them in the name of your living trust. So here's another visual. You got this trust and you got to put everything inside it. And everything inside it will receive the protection that it offers. So here's a sample. Instead of Sam Jones and Betty Jones owning a particular asset, they're going to change the title to say Sam Jones and Betty Jones, trustees of the Jones Family Trust, dated December 14, 2008. That is an example of putting something inside your trust. One of the biggest reasons the living trusts fail is that people create them and they forget to put things in it. They never change title to the asset. So that's what's called failure to fund the trust. And again, it's one of the biggest reasons that living trusts fail. So when you create a trust, you're going to have a cast of characters, is what I call it. So the first cast member is the settlor, and that's you, or you and your spouse, depending on who's creating the trust. The term settlor refers to the person who creates or controls the trust. Sometimes you might see older terms like trustor and grantor. The more modern term now is settlor. The next cast member is the trustee. Now usually this is you at first, and this is the person who manages the trust. The successor trustees are next in line. They're like your vice presidents, and they step in for the trustee if the trustee is no longer able to fulfill his or her duties, so to speak. So you pick who is next in line to manage your stuff. The next and final cast member in most living trusts is the beneficiaries. Now the beneficiaries are those who benefit from the assets, and that means it's usually you at first, but then other people after you pass away become your beneficiaries. So there's your cast of characters for the living trust: the settlor, the trustee, the successor trustees, and the beneficiaries. You get to control the inheritance, which is very helpful. Do you want your children to get their assets all at once? And if you don't have children, do you want your beneficiaries, whoever they are, do you want them to get everything at once? Do you want them to receive things in installments, for example, at certain ages or upon certain milestones? For example, my kids are in their teenage years as I make this webinar, and I don't know if I want them to get everything right away. So my wife and I created an estate plan where my kids get their money or their inheritance in stages. Some at 25 years old, some at 30 years old, and some at 35. And also we have provisions regarding graduating from college and obtaining a degree and other incentives to encourage our children to do things that are important to us. Also, if you create it properly, if it's set up properly, a living trust can protect your children or your loved ones from creditors or ex-spouses in the case of divorce. You can protect your kids from spendthrift tendencies. What do I mean by that? Some kids can't handle money. Some beneficiaries are no good at handling money. So if it's sitting in the trust and it's being managed for them, then it's going to be protected from their own vices. So if you have a child with a substance abuse problem, or you have a beneficiary who is a spendthrift, can't hold on to money, wants to spend it on everything, or a beneficiary who's going through a divorce and you don't want to give them their inheritance because they might lose it to that divorce. Same thing with a bankruptcy. We can create protective provisions in the trust to help minimize that danger. Remember, life insurance proceeds are also the kind of thing a lot of people will just put their children on as beneficiaries of the life insurance policy. Remember, if your kid is a minor, the life insurance company is not going to write a check to them. So the check will have to end up going to the guardian, or the kids can wait until their legal age, until they're adults, at which point, like I said, it's 18 in California right now. So the kids will get a big lump sum check at the age of 18 from the life insurance company. What if the beneficiary of your life insurance policy was your living trust? I think that might be better, because then the money will go directly to the trust and will be protected and managed for the benefit of those beneficiaries, of those children. And that might be a better idea than just having a big fat check written to one of your kids. Also, when you create a good estate plan, one of the important documents is a healthcare directive. Now, some states still call it a living will. A living will is now called an advanced healthcare directive in California. So in California, we don't call it a living will anymore. If you have a document that says living will, it's probably ancient. Sometimes you'll see the older documents that are called durable power of attorney for healthcare. In California, we no longer call it that as of 2001. Also, you have to ask yourself if your healthcare directive or your documents are compliant with the HIPAA laws. Now, HIPAA stands for the Health Insurance Portability and Accountability Act, and this was passed several years ago, but basically speaking, all it really means is that people just don't have carte blanche access to your medical records. So they don't just have access to your records simply by virtue of being your spouse, for example, or your mom or your dad. They have to have legal documents that release those medical records. And of course, you want to create these kind of documents because they give your loved ones guidance, and they prevent arguments about what's going to happen. So if your agent knows what you want and it's written very clearly for them, no one is going to be able to argue with them. They're going to be able to point to the page and say, this is what they want me to do. So a good healthcare directive should offer a great deal of guidance for your agent. Another very important tool in the toolbox is something called the durable power of attorney. In this document, you appoint an agent, somebody to stand in your shoes and make decisions for you with respect to everything that doesn't have anything to do with the trust. So they will have access to most assets that are not in the trust. Remember, your trustee will handle everything in the trust, but there are so many things in life that don't have anything to do with the trust, so your agent under power of attorney can handle those items. And you want to make sure that you have a robust document, not one that's like a 2-page document that you downloaded from the internet. Your powers have to be enumerated very clearly and spelled out clearly so that you have a much better chance of your document being honored. It needs to be really spell out what the agent can and cannot do. And another threshold question that people fail to think about is when the document becomes effective. When does the document take effect? And I've seen people with powers of attorney that says, my document shall become effective upon 2 doctors declaring me incapacitated. Well, I got to tell you, that's a hurdle that you may not want to have. Having doctors declare you incompetent may be very difficult to do. Some doctors are afraid to sign documents like that. Another option will be to have your document effective immediately, so there are no hoops to jump through when it comes time to use this document. But of course you want to make sure you choose trustworthy people, because this document is very dangerous in the wrong hands. Somebody can really take advantage of your family or you if they are not the most trustworthy person. So again, you want to make sure that you choose people who who you trust and love you. There are some other documents that are involved in this toolbox that I talked to you about, the estate plan. First, guardianship nominations. You want to nominate guardians if you have minor kids. Who's going to be responsible for your minor children if something happens to you? Who will have the legal authority to make decisions for them? Also, you may want to employ marital property agreements. For example, is everything community property? Do you have any assets that are separate property? We might want to address those issues. Also, you might have a schedule of assets. It's a very good idea to have a schedule of all of the trust assets in your trust binder, in your estate planning documents. There are several reasons for that are too complicated to get into, but if you don't have a schedule of assets, you might want to create one. I think it would be very helpful. You can also gift personal property items to people in your estate plan. So for example, you might have some jewelry that you want to get to so-and-so, or a very important family heirloom that you want to make sure goes to your daughter or to your son. Whatever the case may be, you can gift specific assets to specific people in your estate plan. Also, there's a lot of things that we have that need to be assigned to the living trust. So there's furniture, jewelry, clothing, articles of personal property that are in your house, assets that need to be assigned to your living trust so that your trustee can handle all of those items for you. Some people have promissory notes that need to be addressed. For example, if somebody owes them money, is paying them in installments. Or this could be a loan of some sort made to a friend or a colleague or even a family member. The question has to be addressed, what are we going to do with those loans? What are we going to do with those promissory notes? Are they continued to be payable to the family? Or will they be forgiven? We have to address these issues. Also, we want to make sure that your real estate is titled properly, that it's not just sitting in your name, that we put it in the name of your living trust if that is the best way for you to protect yourself. If you have a business, we want to make sure that your business interests are assigned to your trustee so that they can act on your behalf. Always ask yourself, if you're a business owner, what's going to happen to me if something happens? What's going to happen to my business? Who's in charge? Who's allowed to make decisions? Who's allowed to sign on my behalf? Will my business be distributed to my heirs, etc.? And then, of course, there are pour-over wills. These are special kinds of wills that work in conjunction with your living trust. The pour-over will is simply a backup to your trust. If we have to go to court, we're going to be able to take this will into the judge, and the judge will understand that you want everything put in your living trust. And so it's just a backup to your trust if you choose to create a living trust. So think of estate planning as a big umbrella. One of the analogies that I like to use is the analogy of the toolbox, but also some people like the umbrella analogy. And under this umbrella are several different things like living trust, wills, guardianship nomination, property agreements, healthcare directives, HIPAA authorizations for medical records and private information, powers of attorney, etc. So the reason I create this particular visual is because a lot of times clients call me and they say, hey, I want a living trust. And I tell them, actually, you're probably asking about an estate plan. A living trust is just one of the things under this umbrella called estate planning. So the final question that people ask is they say, okay, what should I do now? Now that I understand estate planning a little bit more, I kind of get the idea of the legal toolbox. I tell people, just call, make an appointment. It's really the toughest part. So make an appointment with the lawyer that you trust and go see them. In many cases, the first appointment will be free of charge. You have nothing to lose. Also, the lawyer's office will probably give you a questionnaire that you need to fill out. This will help the attorney craft a plan for you and make recommendations to you. Before the first meeting, you want to gather all the important documents, and the attorney's office can tell you what documents those should be. In fact, they might give you a list. And actually, this is a very good part of the process because some people don't know where any of their documents are. So this is a very good way to take inventory, if you will, of all of the important documents in your life. So you want to provide all this information to the lawyer before the appointment so that your meeting can be very productive. And when you go to your meeting, you're going to create a plan with the attorney, preferably Robert Mansour. There's a plug for me, after all. That's one of the reasons I'm creating this video, is to help you learn more about my practice. After the lawyer has created the plan for you, they should send you some drafts for you to review. I also like to include a summary of those drafts, and sometimes I'll highlight particular provisions that I want the clients to really pay attention to. And then you're going to go for that final meeting where you're going to sign all your documents and put everything in place. Now, last thing I want to say, this is not a vaccination, folks. You don't just do this one time and forget about it. I mean, we don't go to the dentist just one time and never go back. We don't go to the doctor one time and never go back. Every so often, every few years, you want to revisit your estate plan. You want to make sure there's been no major changes in your life. You want to make sure that your documents are current. You want to make sure that the plan still says what you want it to say. And you may be surprised every few years you might feel differently about certain things. You may not be so comfortable with the people that you've chosen to serve in various roles. So, I always encourage clients every 3 to 5 years, sit down with your attorney and have a review of the plan. So, all that being said, I hope you found this helpful, folks. This has been Robert Mansour with this estate planning webinar. If you found it helpful, please feel free to share it with others. Let them know about it. And I hope that you are motivated to get started. If you'd like to work with me, give me a call. We'll create our first appointment, and we'll take it from there. Thank you very much for watching this webinar, folks. See you soon.